took a look at the registration list. It looked like many of you joined us for either or both of the first two webinars. So for those of you who've been with us before, we appreciate your continued participation and welcome back. Holly, if you could go to the next slide, I just wanted to cover a couple of logistics as we're getting started. So today we'll have three industry experts speaking. We'll have Stephen Burdick from the INL, Ray Kyler, who's with Westinghouse, and Chris Nolan from Duke, and they'll each introduce themselves as they get started on their particular topics. A couple of logistics for the webinar. Please be sure that your camera is turned off and your audio is muted. We'll be collecting questions throughout the webinar, so you can use the question feature as noted there in the third bullet for providing us the additional topics or questions you'd like to cover in more detail. And the way we've established the agenda, similar to the first two webinars, is we'll anticipate having about 30 to 40 minutes available at the end, and we'll work through as many of the questions that we received during that period as we're able. And then we'll follow up after the webinar with some written responses for anything that we don't get to. A couple of other items, if your organization allows it, we find that these webinars work better if you can disconnect from your VPN software or firewall. And also a reminder that today's webinar is being recorded, and both the presentations and the recorded material will be available on the GAIN website after today if there's anything you missed or want to go back and take a second look at. Next slide. So just very briefly, the agenda for today is, again, Stephen from the Idaho National Lab will talk a bit about available NRC licensing pathways. I think a lot of people are at a high level familiar with Part 50 and its nickname as the two-step licensing process, and then the Part 52 related approaches, which are referred to as one step. But Stephen will go into a bit more detail there, and in particular, we'll talk a bit about the various hearing processes that are involved with both of those paths, and where they fall, what they're intended to do, and maybe where some of the considerations and challenges might be in that area. Then Ray from Westinghouse will talk a bit about various types of information exchange with NRC, along with material that either is required to be or can be packaged in a way so that it's non-public. And then thirdly, Chris from Duke will share some experiences and insights from an owner-operator organization standpoint on the kinds of things, for instance, that Duke is working through as it works through its energy portfolio strategy going forward, and the kinds of things that they consider when they're looking into a new deployment project, the kinds of places where risk and other technical and political situations or challenges may come into play. And then lastly, I'll spend a few minutes in primarily a wrap-up mode. I'll do primarily a review of some of the key points that we covered in webinars number 1 and 2, and again, close out as a wrap-up, and then we'll move into the question and answer period. And again, we expect to leave about 30 to 40 minutes for questions. Next slide. So with that, I'll turn it over to Stephen and let him walk you through the available NRC licensing pathways and hearing processes. And Stephen, before you get started, I'd ask you just take a minute and introduce yourself. I believe your bio may be on the next slide. Thank you.
Great, thank you, Jim, and thank you to you and the other people working behind the scenes to pull together this webinar. I watched the first two webinars and they were very instructive. Encourage everyone to watch the recordings of those if they haven't done so, and hopefully we can continue that and share some good thoughts today. As Jim mentioned, I'm going to talk through the various NRC new reactor licensing options and then the associated hearing processes. I think this is a really important topic. As I work with folks in the industry as they've come into this new reactor world, this has been somewhat of a black box, particularly on the hearing side, where some companies just don't fully understand what these NRC hearings really entail, and so hopefully we can share some thoughts on that and shine light on that black box. I'll just offer up the typical caveat that that these are my thoughts. I don't think I'll be saying anything particularly controversial today, but I will get into some legal questions, and so please don't consider that legal advice. Please work with your own in-house or external counsel if you're faced with some of these questions. And for the Battelle folks on the line, I am your attorney, but I'm assuming we would talk a significantly amount more before we would submit any sort of a reactor application. So don't rely on just these slides. Just by way of just a brief background here, I've been at the Idaho National Laboratory in the legal department for the M&O contractor Battelle Energy Alliance for the last couple of years. I started as an engineer, and my first position was at the Knowles Atomic Power Laboratory in upstate New York, where as a civilian, I went through the Naval Nuclear Power Program to be qualified. And then as my Navy classmates went on to either submarine school or aircraft carriers, I started training others coming up through this pipeline. So I have some kind of technical background there. Shifted direction somewhat by going to law school, but I stuck with the nuclear industry. And so coming out of law school, I worked for the last, before I came to INL, about 15 years with the law firm Morgan Lewis in Washington, D.C. and their nuclear energy practice. And Morgan Lewis, that practice has attorneys that do a lot of different types of legal work. I focused on licensing activities before the NRC with a focus on new reactor projects. And so I'll try to bring some of that experience to my comments today. And I've worked on all the different types of licensing options that I'll discuss. Additionally, as part of that, I've worked on dozens of NRC hearings, and so I'll try to share some of that experience. And then finally, as I mentioned, I'm here at INL right now in the legal department with a focus on environmental health, safety, and quality issues, which sometimes includes some of these topics I'll discuss today. Can we turn to the next slide, please? Just a quick agenda. I won't repeat what has already been mentioned, but I'll talk through these licensing options here and then some of the available hearing processes. I kind of put them into these three bins of contested hearings, mandatory hearing, and then ITAC hearings. And I'll explain what ITAC are later in the presentation. I don't address any of the kind of future activities and development of a Part 53. That'll be covered by other folks in these webinar series. I also skip over some of the Part 52 processes for standard design approvals. I do think that there are some opportunities with the standard design approval to have some flexibility in reviewing advanced reactor projects or new reactor projects or parts of them. And so I think that's a tool that companies should keep in mind. And then also, I'm not going to talk about manufacturing licenses. The NRC has never received an application or issued a Part 52 manufacturing license, but it's something to keep in mind. Interestingly, they actually issued a manufacturing license under Part 50 in the past for a floating nuclear reactor. So there's a little bit of history there, but certainly I think at a Part 52, it would be quite different. Next slide, please. So as Jim mentioned, there is this Part 50 two-step licensing process. And obviously the two steps here are the obtaining a construction permit prior to constructing a facility, and then obtaining an operating license before operating the facility. And so those are the two steps. The construction permit, the application requires information on siting and some higher level design information. But one of the key points I'll keep coming back today is for the construction permit, there's not finality with the design. And when I talk about finality, I'm really talking about the ability for the issue to be re-reviewed in the future or to be challenged in the future in a legal proceeding, in a hearing process. And so the construction permits have very little finality. But on the other hand, and there's kind of tension between these two topics, although they don't have finality, they have a lot of flexibility with design changes during construction. And so we'll see with this Part 52 that tension is kind of flipped the other way. And so I'll talk through that. I do quote this regulation on this slide, 10 CFR 50.35 Bravo, and it really lays this out, that for a construction permit, it's not commission approval of the safety of the design unless it's requested and then incorporated that approval into the construction permit. And as I've looked at this issue in the past, there's very few examples of this, and I think there were a handful, and primarily there were regulatory issues, but not a lot. And this also has the benefit, as I mentioned, of the flexibility with design changes. And when I say flexibility, there is quite a bit there. I remember seeing examples where during construction, a company would change even from once-through cooling to using cooling towers, and that would not require a construction permit amendment. And so I thought that was fairly significant. Next slide, please. With the operating license, it's a similar licensing process, but obviously the information covered is different, much more design detail, and then some of the operating types of issues that are covered, like technical specifications, security plan, and so forth. These operating licenses are issued for 40-year terms, and they can be renewed then for additional 20-year periods. It could be a subject of a whole other webinar for license renewal, but all of the existing operating commercial reactors which have used this two-step licensing process, almost all of them have received a 20-year renewal of their license, and then some are going through the process right now, even to receive a second 20-year. So that's a really, I think, important concept for companies looking at the life of what the reactor could operate. One of the challenges with this two-step licensing process is that there are hearing opportunities at both stages. And with that lack of finality, historically, some of the same issues could come up in both cases. And so there could be this kind of re-review or re-challenge of issues that a company would like to have kind of put aside, particularly when moving forward with construction and the risk that these types of challenges have in the midst of construction. Traditionally, the process has been lengthy and costly. That's not true in all cases. Some of the very early licensing activities went through very quickly, but over the years, as the regulatory regime kind of progressed, that there were more requirements imposed on these applications, and that the hearing process, quality issues or quality questions late, things like that, evolving regulatory requirements. If you did watch the first webinar, some of those issues were discussed by the presenters there, including some of the regulatory changes that came about in response to nuclear accidents. And so you can imagine if you were either licensing a plant or constructing one in the midst of the 3 Mile Island accident, that certainly that could cause some changes and some delay as well. Next slide, please. Here is just a flow chart, just high level for a construction permit. And it's pretty similar for a lot of these licensing activities at the high level that we're looking at, with some key differences. So, the application is submitted, there's pre-application interactions with the NRC. The NRC will look at an application and determine whether it's sufficient to move forward with the review, and eventually will make a docketing decision if it reaches that conclusion. At that point, then the staff will perform its review, both from a safety and environmental standpoint. From a safety standpoint, the ACRS, the Advisory Committee on Reactor Safeguards, can review safety issues. In webinar 2, Ryan Leidy spoke some more about the ACRS. But once the NRC staff is done with its review and all of these pieces of it, then this process will move into a mandatory hearing. And then once that's done, there will be a decision on the construction permit. I'll get into the hearings more later, but I do put on this slide in red, these red boxes, the mandatory hearing process towards the end, which I think is important to note that that is by definition on the critical path for receiving a construction permit. And then earlier on, though, the contested hearing opportunity, there will be an initial point where the NRC, around that docketing decision, will issue a notice in the Federal Register allowing interested parties to submit a hearing request challenging an application. And so there's a point in time where that begins. You'll see that there's this right arrow on that same red box to make the important note that opportunity doesn't necessarily end on that single day. There are opportunities to try to petition to intervene and raise new challenges throughout the hearing process or throughout the review process if there is new and materially different information. And I'll talk about that briefly later. Next slide, please. This is the very similar approach that was for the construction permit, but for the operating license. The primary difference here is that there is no mandatory hearing opportunity, but there still is the contested hearing opportunity at the beginning. All right, let's go to the next slide. I mentioned some of the challenges with the Part 52 step process, and others I'm sure have some additional thoughts or their own thoughts on that. But some of those challenges led to the NRC and industry and developing the Part 52 licensing process. And so that became a final rule back in 1989. It's been around for a long time. It was used some in the 90s, but it was really in the 2000s when a lot of the activities were going on. This is just a diagram from an NRC document, this new Reg BR 0298 that I like, and really shows how the process works. But this Part 52 process is sometimes referred as the one-step process. Somewhat of a confusing phrase. Really what it's saying is, you can see in the middle of this diagram in the dark circle, the combined license. And so really there's one licensing action that both authorizes a company to construct and to operate the reactor. And so that's the one step. You're taking the two licensing actions and putting them together. But obviously there's many more steps throughout this process. And you can see here on the left, there's pre-application work, obviously, or working with the NRC. Then there's these opportunities to both obtain an early site permit or design certification. These are the boxes on the left. And then those can factor into the combined license review. These are not mandatory. And so most companies, and I think all companies, have referenced a design certification, and I'll describe that in their combined license application, but only a handful have used an early site permit and refer to that in their CO application. And then after they get the license, that doesn't mean there's not NRC involvement. There's close NRC involvement during the construction period with the verification of both the company and the NRC inspection of the closure of the ITAC that I mentioned earlier, which stands for Inspections, Test, Analyses, and Acceptance Criteria. And then once those ITAC are all satisfied, then there's a process for moving into reactor operation. Let's go to the next slide, please. So looking at design certifications, as I talked about before, this is really approving the design. The word certification is there rather than just approval, because this goes through a rulemaking process where certain design information really becomes part of the rule through that rulemaking process. There's an opportunity for public comment during that rulemaking. I point here on the slide to the design control document. For other existing plants or for other projects, there's typically a safety analysis report maintained with the safety design for the plant. Here, there's the design control document. But that has two tiers. The higher tier is the top level design information. And that's really the information that's officially being certified in the design. There's a tier 2 that's similar to the FSAR, the final safety analysis report that exists for existing reactors. That design certification includes these ITACs spelled out, and there's quite a few of them. I remember in some cases there were 900 or 1,000 or so of these ITAC in the design certification that then become part of that combined license. Here is kind of have the opposite of what I discussed with the construction permit. Here there is a tremendous amount of finality for the issues that are certified as part of this process, meaning that those can't be re-reviewed and they can't be challenged by intervener groups during this COL review, the combined license review, except for certain exceptions. Obviously, if there's a true safety issue, then the NRC has tools to be able to address that. Because there is this level of finality, though, then there is a much more structured departure and change process, primarily laid out in Section 8 of these design certification rules. And it goes through the process that depending on the level of information that is being departed from, what level of NRC review and then what the process is. In some cases, if it's certified information, it can even require an exemption from the rule, similar to what would be for departing from any other NRC rule. So I think that's a really important piece. These certifications are issued for 15 years, but then may be renewed as well. I think an interesting point that because it goes through this rulemaking process, it's kind of out there for anyone to use. As a practical matter, it's probably the applicant who will be the one who is qualified as a vendor to provide that reactor, but there is no limitation on others as long as they can demonstrate that they are qualified to do so. All right, let's turn to the next slide, please. This is the flow path. This comes from the same NRC document, except I've added this red box. But kind of like the construction permit, because we're looking at this at such a high level, where applications submitted, there's the NRC review meetings, ACRS review, but it's really the second box from the right where there's the design certification rulemaking that this differs, from this process flow chart. This is notice and comment rulemaking. So the NRC will publish the proposed rule and information about the rule, and then that's subject to a public comment period. And so that's really the way that the public can participate in this process, even though there's not the hearing that like we're going to talk about elsewhere. All right, next slide, please. Here's a table of the design certifications that have been issued and or are pending at the NRC. So you can see that they're listed on the left, that the first 6 all have their own appendix in 10 CFR Part 52 following that certification process. There's EPR and APWR that are suspended at the NRC. And then the NuScale design certification. The NuScale project has completed its safety review by the NRC, and it's still going through this design certification rulemaking to complete that design certification process. I provided some dates here just for information, but please take these with the background in which they occurred. Certainly the first couple of design certifications that started even in the late 80s, that there was a lot of effort to develop what this means and the different tools that factor into the design certification. So those were complicated in that way. And there's some that went through a little faster. Certainly sites, specific applications may have their own considerations, but you look at the more recent ones, like the APR 1400, about 5 years, and then NuScale, I think less than 4 years for the review, and then we'll see the rulemaking. That's probably a more standard for these types of reactors. Hopefully for the smaller designs, there's even more efficiencies to be had there. I will point out the AP1000 may be a little confusing. The AP1000 certification happened in the early 2000s, but then there was a significant revision that when people think about the AP1000 today, was issued in 2011, that's really the design that they're thinking of. But next slide, please. Let me talk quickly about the early site permit. Some of this had been covered in webinar number 2, and I think Chris will talk a little about early site permits too. But at a high level, these early site permits will approve a site both from a site safety and a environmental standpoint. So I point to NEPA here, the National Environmental Policy Act. And so pretty robust and full discussion of those issues, both in the application and in the review by the NRC. There are certain things that don't have to be provided, like a need for power analysis or a full emergency plan, but they can be, and that will really depend on the company's strategy. If they're really moving straight into a COL proceeding, then they may want to address all of those issues. These can use a plant parameter envelope. In fact, all of them have, except for the Vogtle project, where it knew it was going to construct the AP1000 design. The plant parameter envelope, as the name, I guess, kind of implies, is a generic bounding envelope of different reactor parameters that the applicant prepares, and then the NRC reviews against that. And then later in the COL proceeding, then the applicant will have to demonstrate that reactor, once they've actually selected design, falls within this plant parameter envelope. The ESPs are valid for a period of 10 to 20 years. I think they've been 20. but they may be renewed as well. And the idea is, in some cases, people call it, you can bank the site for a future project. Here again, like the design certification, there is finality in the COL proceeding, that the issues resolved as part of the ESP cannot be further challenged. There are some exceptions. As I mentioned, if the later reactor doesn't fall within this plant parameter envelope, then that will have to be considered and reviewed as part of the COL project. Also, if there's new and significant environmental information, that will have to be considered as well. A key point that the early site permit does not approve construction. However, projects can try to obtain what's called a limited work authorization from the NRC in parallel, or also at a different time. Parallel kind of makes sense because you're looking at a lot of the same types of site safety and environmental issues. But if you don't get the limited work authorization, you don't have authority to do any construction. All right, next slide, please. Here is the flow chart for the early site permit, and again, kind of high level, similar types of process. Key issues here is on the right-hand side. You can see that there is a mandatory hearing, and I'll explain that later. And then you still have the contested hearing opportunity earlier on. There's still the ACRS review because it's not just environmental issues, it's still the site safety that falls within some of the scope that the ACRS typically looks at. All right, next slide, please. Again, a table of the issued early site permits. There's been 6 of them. There was 3 of them that started in the early 2000s, then the Vogtle project, and then PSEG was a little later, and then finally the most recent was TVA's Clinch River project. They all use PPEs except for the Vogtle project, and then for Clinch River, that was very focused on small modular reactor designs. Here you can see the duration of some of the reviews. Typically, 3 years, 3 to 4 years. PSEG was a little longer. There were a lot of hydrology questions that came up. And then maybe the last point I'll make here too, the 3 years and however months, for example, for the Clinch River, it's a little misleading that that's not all purely NRC review. For that project, in some cases, the NRC is looking for more information before they'll officially docket the application. So there are some months in there, and that's when they officially begin their review. And then, as I'll keep pointing out, the mandatory hearing becomes part of that critical path at the end. So when you take those 2 times off, the NRC review is shorter than these durations here. All right, next slide, please. Finally, with the combined license, this is really where, under the Part 52 licensing activities, that it all comes together, because this is where you get the authorization to construct and operate. I mentioned before the ITAC and the ability to reference these other design certifications or early site permits. The application more detailed, and now you're really getting into a lot of the operational activities like emergency planning and so forth. Like the operating licenses issued for 40-year terms, but they start at a different point. So for the combined licenses, the 40 years really starts from when the 52103G finding, I'll explain that a little more, but when all the ITAC are complete, because there's that period of construction. So really 40 years from when you're done with the construction, and then that may be renewed as well. Next slide, please. So here again, the process flow from an NRC document. And finally, for the first time, we see over at the right in the red box, the ITAC hearing opportunity, but plus you still have the mandatory hearing, and then you have the contested hearing opportunity. But the ITAC hearing opportunity is really tied to the COL and completion of the construction under a combined license. Okay, next slide. Not as many details here. I just took a couple of screenshots from the NRC's webpage on the combined licenses. On the left-hand side, these are all the applications that have been submitted and then their current status. Only the Oklo application, most recent application, is under review. The others have either resulted in the issuance of combined licenses, and those are shown on the right-hand side, or the applications have been suspended or withdrawn in some cases. I think if my count is right, there's 19 applications submitted for COLs, in covering, because a lot of those are 2-unit sites, covering 29 units. And it's interesting to me that on the right-hand side, with the COLs issued. There are, I think, 14 of those. And so if you take out the Oklo application, really, half of the 28 units have resulted in combined licenses. You'll see that some of these have been terminated. And I think that's important, both the termination of the COLs, but also the applications that have either been withdrawn or suspended. Primarily a business decision by the companies. There's lots of factors that go into that. There's still some cost, but also perception and energy planning that factor into that in the discussion of whether to keep an application going or to keep the license itself. So, companies have to make those decisions for themselves. Next slide, please. Finally, last slide on the COL topic. We talked about ITAAC a few times, but here's kind of the process for finishing up the ITAAC and what the ITAAC are. The ITAAC are really there to demonstrate to the NRC, the public, and the company that the plant has been constructed in the manner in which it was designed and approved in the COL proceeding, and to show compliance with other regulatory requirements. As I mentioned, there are hundreds of these ITAAC for each project in the past. Some of them are pretty simple, but some are extremely complicated. I give one example here, but again, very simplified. Perhaps in the design certification, there's a safety-related cooling pump, and it's required to pump 100 gallons per minute. Then you look at the ITAAC, so there's the ITA portion, so the inspections, tests, and analyses. So for this example, it may just be to test the pump flow rate. And then the AC, or the acceptance criteria, then is to demonstrate that the pump flow rate is greater than 100 gallons per minute. So once the license holder at this point once it's done this testing, it will document the results, and then it will submit to the NRC an ITAAC closure notification, telling the NRC that the COL holder believes that this is done. The NRC will review all of those submittals. It also will do some inspections on site, and so there's close coordination between the COL holder and the NRC about when these ITAAC closure activities are occurring, so the the NRC can inspect them if it desires to do so. Once the NRC reviews and it's satisfied, it will publish a notification in the Federal Register that those ITAAC are closed, and then once all of the ITAAC are closed, then operation can proceed once the NRC issues this 52103G finding that all the ITAAC have been satisfied. I think this process shows that there's close coordination during construction. Even though it's this one-step process, it doesn't mean the NRC's hands off. In fact, there's extensive oversight and on-site inspectors in this process. And the NRC, certainly if there's a safety issue with starting up or operating a plant, it retains that authority to stop that from happening if it really believes there's a safety issue. Next slide, please. My final slide on some of the licensing activities, just to compare some of Part 50 versus Part 52. Maybe in a few years it'll be versus Part 53. But here with Part 50 and 52, I talked about a lot of these items here, but Part 50, it will allow a company to start construction much sooner and faster than under the Part 52 process, and also with maybe a design that's not quite as complete as is required under Part 52, which requires an essentially complete design. So this also factors into that flexibility and the finality. Again, under Part 50, there's not a lot of finality until the operating license stage, but then you have more flexibility during construction. And then the contrary is true under Part 52. There hasn't been a lot of recent experience under Part 50 for licensing. However, there has been some related to medical isotope facilities that I think can provide some good background here as well. The Shine Medical Isotope in Northwest Medical Isotopes have construction permits under Part 50, given the nature of their facilities. So there's some good precedent there. And then, some of the challenges I mentioned already with repetitive hearing opportunities under Part 50. But Part 52, on the other hand, has pretty extensive licensing experience in recent years. It hasn't yet resulted in operation, but we should see that pretty soon with Vogtle units 3 and 4. And maybe just a key message from my thoughts is, there's a lot of differences and a lot of different combinations of these licensing approaches that can be taken by a company. And so a company really needs to find the right approach for itself, both as it discusses it internally, legal counsel perhaps for some of the issues, and then as it talks to the NRC about some of the real implications of this. So really important to look through these topics. Next slide, please. This is kind of the second half of what I wanted to cover now, is to circle back to the contested hearing, the different hearing activities. Here is just an excerpt from the Atomic Energy Act. Section 189 includes the hearing opportunities. Don't expect people to be able to see this, but you can see on the right, there's not a lot of words there on hearings, but then there's a lot of hearing procedures. So I think the point is the NRC has a lot of flexibility in how it interprets what it does for hearings, and it's done so. Next slide, please. The contested hearing is, I think, what most people think of when they think of an NRC hearing, where there are members of the public or environmental groups that are challenging a project. And so they submit a hearing request, and that's kind of the start of the discussion here. There are 4 primary requirements for granting a hearing request. And that's really the important threshold for someone to get their foot in the door to have a hearing and to engage further. So if a hearing request is granted, that doesn't mean that an applicant's lost. It's really just trying to get past that initial hurdle of, should we even keep going with the hearing process? So these 4 requirements, the first one may be self-explanatory, but there has to be a hearing opportunity. Occasionally, these groups will file certain petitions with the commission that are outside of a hearing opportunity, or maybe it's earlier than the hearing opportunity even exists. So typically those have been rejected, or they sit long enough that maybe then there is a hearing opportunity and they're modified. Second requirement is they have to be timely. For most cases, once the NRC publishes their notice of an opportunity for a hearing, there's 60 days to submit the hearing request. As is typical in legal proceedings, most groups will wait until within the last couple of hours of their deadline. So, a couple hours from midnight on the deadline day. And so computers don't always work the way we want them to. So it can create some confusion. In some cases, they just miss the deadline altogether or decide later on, hey, I really did want to challenge this. So a response can be, there's a timeliness requirement for that as well. They have to have standing to intervene. That's really just a right to be able to participate in the process. And the NRC follows some of the traditional standing requirements. They have to show some sort of a harm from the activity. There must be a link between that harm and the activity. And also with whatever the petitioner is requesting, it must be able to redress what that harm is. And so those things are really, really connected. The NRC also follows, though, and this covers standing issues for most of the reactor proceedings, is it has this proximity presumption. And so for the licensing of let's say, large reactors, the NRC will conclude that if a petitioner resides within 50 miles of a facility that's being licensed, then there's a presumption that they have standing. Now, the applicant or the NRC staff, if they chose to do so, can push back on, it's only a proximity, and can argue that hey, with this licensing action, there is no obvious potential for offsite consequences. And perhaps that will be an issue that will be more relevant with the smaller reactors. If they have an emergency planning zone of a building or a small site, maybe there's some arguments there, but that's a threshold that will have to be dealt with. And then finally, there must be an admissible contention. So contention is really just the challenge to the project, the challenge to the application. And admissible means that it's found to satisfy the 6 requirements that are listed here on this slide. Just quickly on these requirements, I think they're important because this is really where most of the discussion and argument occurs. The first couple are pretty easy. They just have to state, hey, what are they actually controverting? What is their problem with the application? And give some basis for why they're challenging that. The third item becomes more important with the scope of the licensing action. So if the challenges are being raised are really just countrywide or worldwide issues that don't really tie to this application, then those are outside scope. With this finality question I've been talking about, if in a COL proceeding, an intervener tries to challenge what was already resolved in a design certification, then that would be outside of this scope. And so that could be the response here. The next couple requirements has to be material to the findings that the NRC makes to issue the license. It has to have some support. It doesn't have to be detailed expert support, but some support for this. And then finally, where I find a lot of the discussion is on whether a contention is admissible, there has to be a genuine dispute. And so part of this is, hey, does it even matter? Is there even a disagreement, or are they just picking at some things in the application that really isn't that important? Or in some cases, in more than you would think, the petitioner may challenge an issue and say, hey, this is not addressed in the application, when it really is. And so if that's the case, then the applicants can say, well, that's just incorrect. Here's where it's addressed, and it's been addressed, and so there's no genuine dispute. Maybe it's not as surprising because obviously, I keep saying obviously, but these applications can be very lengthy and technical, so sometimes it can be difficult to find that specific information. All right, next slide, please. So the NRC's requirements for the process and for the hearing are primarily found in 10 CFR Part 2. Subpart C of Part 2 gives some of the rules of general applicability. And so some of the stuff I've been talking about contention admissibility are there. But then there are a couple other subparts that are important to talk about. Subpart G are rules for formal adjudications. And then Subpart L are simplified hearing procedures. The default for these types of proceedings are Subpart L. And so the simplified hearing procedures, one of the big differences is under Subpart G, it's more like a traditional trial, depositions, interrogatories, cross-examination of witnesses. Those do not exist under Subpart L. There is some ability to request cross-examination, but under Subpart L, simplified is a little bit of a misnomer because it's still a very complicated and can be lengthy process, but it's a lot more written filings, and then rather than the cross-examination from the opposing party, the licensing board will be involved with asking those questions. So once a hearing request comes in, it will go first to the commission and its office of the secretary. That hearing request, or all of the hearing requests, if there's more than one, are then almost always referred to the Atomic Safety and Licensing Board panel. And in webinar 2, Ryan talked about this panel as well. But it's all of the judges that are at the NRC that participate in these proceedings. And then that panel will then designate 3 judges that will oversee this specific proceeding. And it has a lot of authority, ruling on hearing requests, extension requests, motions, schedule, all of that. Normally, there is one legal judge who has legal background, understands some of the process requirements. And then there's normally 2 technical judges. They all kind of weigh in on everything. Sometimes the technical judges even have or try to be assigned based on their background, technical background, that lines up with what the challenges are in the hearing request. So there could be a technical judge with let's say a geological background, and if those issues are being challenged, and it helps sometimes because then they have you can dig into the contentions in a little more detail. Just a word here on contention topics. It has to be things that are inside the scope of the proceeding. So that's going to depend on the type of the application, but they're pretty wide reaching. So it tends to be more environmental challenges. And so things like endangered species, need for power, environmental justice, the environmental impacts of water use, those types of issues. Sometimes safety issues with accidents or things like seismic hazards. But there can be other topics as well, like financial assurance, foreign ownership questions, and so forth. So those, you don't really know until you get the challenge. Maybe sometimes a company will understand that something potentially be controversial, and they can prepare accordingly. I make the point here at the end of this slide that proposed contentions are not all equal. There could be a contention that's a paragraph long and is just missing something in the application. Well, that's really easy to deal with. But on the other hand, there could be a contention that's challenging cooling water, and that could be dozens of pages and supported by dozens of pages of expert declaration. That will take more time to address than the first contention. And so just talking about the numbers of contentions may not be the most meaningful information. But next page, please. Next slide. Okay, I think of the contested hearing in kind of 3 phases, and this is the first phase, and then there's one on each page. So this is early on, and most of what I've been talking about so far. There's an opportunity for a hearing. Then starting at the top left here, there's 60 days for petitioners to submit hearing requests. The licensing board is appointed. Applicants and the NRC staff have 25 days, and after that hearing request, to submit answers. Then there's 7 days for reply. At the discretion of the licensing board, there can be oral argument on those hearing requests. And it's not a technical oral argument. It's focused on whether the hearing request requirements I've talked about have been satisfied or not. And then finally, at the top middle box here, the licensing board will make a decision on whether the hearing request or request should be granted. It normally takes about 6 months or so from when there's the opportunity for a hearing until when the licensing board issues its decision on the hearing request. I think a key point here is this activity is not on critical path. This is being done in parallel with the NRC staff proceeding with its reviews, and so this alone will not extend the time frame. Now, depending on where this goes, that's where timing becomes important. From here, once the licensing board issues decision, you can see that there's an appeal opportunity, and this interlocutory, meaning it occurs in the middle of the proceeding. It's limited. It's really only if a petitioner's hearing request was rejected, it can appeal it. If the hearing request was granted, then the applicant or the NRC staff can appeal it, but only if they appeal it in a manner that it would be entirely rejected. So the appeal standing or the admission of all of the contentions. Scheduling orders and then mandatory disclosures. I'll talk about that on the next slide. Next slide, please. This is what I think of as the second phase. So now we're assuming that there's a hearing request that has been granted. There are these admitted contentions. So there can be efforts to try to dismiss or narrow the admitted contentions to get rid of them. And a couple of means to do that. There could be motions for summary disposition. This is similar to motions for summary judgment and other legal proceedings. And here it's really that, hey, even if everything the petitioner said is correct, it really doesn't matter. It's not an issue that the NRC needs to make a finding on. The difference here from contention admissibility is here you can get into the technical arguments, and so you can have expert affidavits. In some cases, applicants can amend their application to address the challenged issues. And if they amend it in a manner that it's now a moot issue, so it's just gone, then they can move to dismiss that contention. But settlement is always an option as well. Settlement's a little challenging in these proceedings. Some of the petitioner groups are not just trying to address their issue of, let's say, an endangered species. Their efforts may be to stop the project, and so it's hard to reach a settlement if one of the sides, their only solution is something that just can't be done, for the applicant side. So it doesn't get used all that often. Another important issue that comes up during this phase with admitted contentions are mandatory disclosures. These are fairly significant effort to prepare these, depending on the admitted contention. I quote the regulation here, but it talks about all documents, or it's really any item that's in the possession, custody, or control of the party that are relevant to the contentions. So relevant is a very broad phrase, so depending on the nature of the contention. Sometimes the parties can reach agreement to try to limit some of the burden here. The regulations would require kind of lists of some items, some documents, and maybe the parties agree that those aren't needed or they don't need to identify drafts. There may be a protective order if some of the information is business proprietary. And then finally, the NRC staff has its own obligations as well during this time frame to prepare what's called a hearing file, which includes some of the application documents, but also any documents they have that are relevant to the contention. So this can be very burdensome, depending on the nature of the hearing request that's been granted. And then finally, in the earlier flow charts, I had for the contested hearing a red box with an arrow pointing to when it happens, but also a box to the right. This next bullet on newer amended contentions is really tied to that. There are 3 requirements for a petitioner to submit a new or amended contention, and it's really that the information their contention is based on is new. It's materially different than information that was previously available, and then they bring their challenge in a timely manner. But this can have a potential impact because it allows, later in the process, hearing challenge or hearing requests, and can affect the proceedings. Next slide, please. This is the kind of phase 3, I think, of the contested hearing process, where now you've got a hearing request that was granted earlier, and you have a contention that is going to an evidentiary hearing. So efforts to try to reduce it or remove it were unsuccessful. And here's a process. I mentioned it a lot more in writing with these direct statements and written testimony. The direct statements or the statements are really the legal pleading that accompanies the written witness testimony explaining why your side should prevail. And depending on the license board have flexibility, there may be direct testimony. It could be one party, or it could be simultaneous filings. Rebuttal, there may even be sur-rebuttal, so keep responding to each other, but that's something to work through with the licensing board. Another interesting aspect, I mentioned earlier, there's typically not cross-examination in these evidentiary hearings. There's the ability to ask for it, but it's a pretty high standard to get that granted. Instead, there's a process where the parties can submit proposed questions for the board to ask during the hearing. And so these are submitted under seal, so only the board sees them, but the applicant can propose questions. If they think there are problems with the testimony they've read, they'll propose a question for the board to ask. There can be evidentiary challenges, and then finally in the top middle, the oral hearing. This could last a half a day if it's a simple contention. It could last multiple days, or if there's many contentions, it could last much longer than that. It just really depends. After that in-person hearing, then there are post-hearing filings such as these proposed findings of fact and conclusions of law, which are really you're proposing to the licensing board what you think the decision should be based on all the testimony. And then finally, the licensing board will issue its initial decision. There's a lot of variability in the timeframes, but kind of from when it's able to move forward with this process till this initial decision, it can take about a year. And so depending on the timing of other review activities, this may or may not be on the critical path. After this initial decision, then there are appeals to the commission and then appeals to the federal appellate courts. Let's go to the next slide, please. This is the mandatory hearing. Again, just very minimal language in the Atomic Energy Act, and then that's been fleshed out by the NRC for the process. Next slide, please. That language in the Atomic Energy Act refers to these mandatory hearings for construction permits. So it applies to construction permits. It also applies to combined licenses because they're authorizing construction. But maybe the one that's not as straightforward, the NRC also interprets ESPs to be partial construction permits, and so there are mandatory hearings for ESP proceedings. Mandatory, as the name implies, so even if no challenges from the contested proceeding, still we'll move forward. The applicant and the NRC staff are the only parties, so the feel and tone of these are much different than because it's not that adversarial process. The commission has the ability to conduct these themselves and has done it for a lot of the COL proceedings, but they can also delegate to the Atomic Safety and Licensing Board as well. It really begins the process when the NRC staff completes its review And then it develops a SECI paper, which is just the paper that it sends to the commission, where it lays out why it thinks that the license should be granted. And so at this point, the NRC staff is fully on board. It's had all its questions answered. It's been through all the meetings and everything. And so it's really just this point. From the time that the staff issues that SECI document, which will be after the final safety evaluation report and after the final environmental impact statement, about 6 months or so until the commission or the delegated licensing board issue its decision on the mandatory hearing. Next slide, please. Here's the process, and I've mentioned a lot of these things. Maybe just point out there is a process for pre-hearing and post-hearing questions and answers. So the commission, I think, or the licensing boards have had questions, and in some cases they'll even identify whether they want the applicant or the staff or both parties to respond to it. The in-person hearing itself, I think the first ones took a couple of days. More recently, they've been about a day. There have normally had presentations by a panel of the applicant on a topic identified by that presiding officer, and then a panel from the NRC staff. Maybe there's different scopes with those presentations, but then the presiding officer, so the commissioners or the licensing board judges, whoever signed that proceeding, then have the ability to do question and answer with the people who are there. In some cases, it's almost like an ACE or S meeting if you've been involved with those, but you're looking at different types of issues. Post-hearing question and answer, I mentioned that, and then finally the decision at the end here. Next slide, please. The final topic I want to cover here are the ITAC hearings, and I'll cover it at a pretty high level. Again, here we have language from the Atomic Energy Act. Next slide. I talked a little more earlier about what the ITAC do. Towards the end of the process, the regulations require that the COL holder submits what's called an uncompleted ITAC notification, or UIN, at least 225 days before scheduled fuel load. So the COL holder at this point, be working with the staff, so what the scheduled fuel load is, and so just what is expected to be, and then it will submit this UIN at the right point. This is an interesting filing because it's fairly lengthy. It will tell the staff, and the staff already knows a lot of this, what ITAC have already been completed and how they've been completed. And then I think what's interesting, it will also say how it will complete the remaining of the ITAC. So there's quite a bit of information then that's put on this docket for the project that lays out the information about these ITAC. So then the regulations require that the NRC issue a notice of intended operation at least 180 days before fuel load. And so the name's a little confusing here, but as part of this notice of intended operation, it provides the opportunity to request an ITAC hearing. So this notice is really what starts the ITAC hearing process. What's important, the staff has worked with public and with the industry to develop what the procedures look like for the ITAC hearing. And one thing that they've discussed and agreed upon is that the notice of intent operation can be published earlier, up to 285 days before fuel load, if that UIN is submitted earlier to support it. This is really important because it gives more time for the ITAC hearing to take place. The key point is that the ITAC hearing is not a new opportunity to challenge the project or the COL application or the design. It's really narrowly focused on whether, and you can see here, whether all of the acceptance criteria for the ITAC have been satisfied, and that must demonstrate that there's some specific operational consequence of that happening. Must still show standing and meet pretty much the same contention admissibility requirements, except for the genuine dispute issues replaced with this kind of prima facie issue that's listed on the slides. So it must show that there's a real consequences and that the ITAC hasn't been satisfied. Prima facie just is a kind of legal threshold, means on its face, so it's kind of apparent that this is true or not. The petitioners can also bring claims of incompleteness, they're called, where if they feel that they don't have the information needed to determine whether the ITAC have been satisfied, then they can submit this claim of incompleteness. And if upheld, then the COL holder needs to provide some additional information to that petitioner, and then they have an additional opportunity to submit a contention based on that new information. Next slide, please. The process for the hearing is somewhat similar to what I described earlier for the contested hearing, but it's been modified somewhat to try to simplify, given the simplified nature of ITAC hearings, but also because of the expedited schedule of them. And there was a lot of work a few years back to develop these ITAC hearing procedures that are published in the Federal Register. There can still be these case-specific changes, but there's even these templates that will address certain parts of the process, such as the notice of intended operation, to make it a little bit easier. There haven't been a lot of these ITAC hearings. Really, it's just the Vogel project that's kind of, for Unit 3 has moved in there. There was a hearing request, but it didn't go very far. So the full extent of these procedures have not been ever utilized. The process begins in front of the commission, but portions can be delegated to the licensing board, such as evidentiary hearings. Next slide, please. This is my last slide on ITAC hearings, and I just have one more other slide. But these hearings are, I think, important because there's a potential or the risk of delay in operation. You can see here from the NRC regulations, 52103E, that the commission is to the maximum extent possible. So there's a little bit of that gray area. Should render a decision on these hearing requests either 180 days before or within 100 days of publication of that notice of intended operation, or the fuel load date, whichever is later. So they can kind of fill that remaining time period, and it just is going to really depend on the hearing, what the hearing covers, and some of those activities. Tight hearing schedule, and you're really near the end of construction. There's chances for kind of late challenges as well. What helps to counteract that is the Atomic Energy Act and the rules allow for, in some cases, interim operation. So under 10 CFR 52103C, pending the completion of these legal proceedings, of the hearings, if the commission has reasonable assurance that the challenge issue isn't going to present a safety issue. And so some of the examples that have been discussed is, perhaps the challenge issue won't be present during a period of interim operation. I'm just making up examples, but maybe it's an aging issue that they're challenging, and it's just not going to come about for a decade or so. Or there's sufficient mitigation measures if a system is claimed to not have met the acceptance criteria, and the COL holder can say, well, we've got this additional mitigation, so even if that fails or whatever the challenge issue is, it's not going to matter. So that provides some flexibility here as well. Okay, next slide, and this is the last of mine. Next slide, please.
Steve, Holly's lost power, so we are trying to get it set up on my computer so that I can do this for you.
Okay, sure.
Sorry.
I think I can address my last slide here. It was just my key hearing takeaways, and that'll be in the slides that people have. But one of the key points is this is definitely an adversarial process. Putting aside the mandatory hearing, but the contested and ITAC hearing. So that presents some additional complexity and for kind of public releases and those that people in the companies, press groups and legal need to be involved in. If almost every new reactor proceeding has been challenged with some sort of a hearing request. At one point I looked, and there was really just, I think, maybe one project. I don't know whether it's more than that, but very few projects that have been challenged. I think I'm on slide 32, if you're able to change it, but I'll just be talking either way. But the level of challenge can vary greatly. So in some cases, like I said before, it may just be an individual, and it may be a very simple contentions. that can be addressed pretty candidly, or it can be, 5 petitioner groups and extensive challenges. So a wide variety. Potential for delay, I've talked about that some. ITAC is pretty obvious because it's happening at the end. Mandatory hearing is on critical path for licensing. And then finally, for the contested hearings, I don't think I mentioned this yet, but whether you can proceed with the contested hearing, the evidentiary portion, will depend on the type of contention. So for an environmental contention, it can only proceed once the NRC issues their final environmental impact statement. So if the safety review is going to take an additional year after the NRC has issued their final environmental impact statement, then that environmental contention, the evidentiary hearing, probably can take place not on critical path. But if it's the reverse, the same kind of schedule, but it's a safety contention, then you may not be able to start until later in the review, and then that could potentially add some delay as well. Structured process, but each one's going to be unique. Prepare ahead of time. I think that was one of the goals I wanted to have today, is so people understand what the hearing process, so it's not a surprise and people can account for it. I think Ray will talk more about some of the documentation, but to prepare, have the right documentation available, because some of this information may become public, and account for hearing options in schedules and budgets. And maybe one last point at the bottom of this slide, applicants typically prevail eventually on hearings because they have the flexibility, they can fight the issue and then prevail, but also the flexibility, if it really is an issue that's going to is a game changer for the licensing activity, to modify their application to address the concerns. I gave some examples earlier, but let's say there's a claim that something's missing, like an endangered species hasn't been acknowledged. Well, that can be addressed either in the application or sometimes in the staff's environmental impact statement, and they can resolve that issue, or even on design issues. So there's some of that flexibility. There are some issues, there was one example in the past with foreign ownership. That's can't be changed readily. And so those are the issues where maybe there's a bigger challenge. But I like that there are some flexibility for applicants. So thank you for your time. I look forward to the question and answers, but I'll turn it over to Ray Kyler for the next presentation.
Can you guys see the screen?
Yes, I can.
Okay, so the presentation is up. I just want to make sure before I unmute.
Yep, I can see it.
Perfect, thank you.
All right. So if I'm on, next slide, please. So my name is Ray Kyler. You can see my bio here. I work in the Westinghouse legal department and have for the last 5 years or so. Before that, I worked in the Morgan Lewis nuclear practice as well, worked with Stephen. And before that, I was an operator and surface warfare officer in the Navy. So next slide. All right, so I really appreciate the opportunity to speak with everyone today and present and share perspectives from Westinghouse as a designer and vendor for the existing fleet and hopefully for the future advanced reactor fleet as well. Next slide. So we're going to talk about the scintillating topic of non-public information in NRC licensing proceedings, or if it's not scintillating, I think it is important to be familiar with and make sure you follow the right processes. We'll talk about proprietary information, other types of non-public information, and a little bit about confidential information in the hearing process. A couple of disclaimers. Of course, these are my own views and not those of Westinghouse. And I am, of course, I'm not giving legal advice today either. Like Stephen, my clients are in Westinghouse, so this is just general background. And I also should thank one of my predecessors, one of the former regulatory attorneys at Westinghouse, who put together a good amount of the information in the slides we're going to be talking about today. Next slide. All right, so we'll start with the statute, or at least one of the important statutes here, which is the Freedom of Information Act, which has been in place in the U.S. for more than 50 years. And its basic purpose is to allow citizens to understand how their government works by allowing them to have access to government documents. And the statute allows for a right for the public to request and obtain agency records. And we'll talk a little more about what that means in the NRC's context. There's a presumption of disclosure unless there's an exemption set forth in the Act. And we'll be talking a lot today about Exemption 4, which is the one that covers proprietary information. As a general matter, business confidential proprietary information is exempt from disclosure under FOIA. Next slide. So under the statute, we've got the NRC regulations, and 2390, the 10 CFR 2390 is the primary regulation we'll be talking about today, and that predates FOIA, but it really sets forth similar standards, right? And so in general, a document that's provided to the NRC will be disclosed, can be disclosed on the NRC website, and generally will be, and can be subject to a FOIA request unless an exemption applies. And we'll talk a lot about what's in that regulation. 10 CFR Part 9 is a separate rule that governs FOIA requests from the public. This is the process by which FOIA requests are handled by the NRC. And it defines agency records as those records that are in the possession and control of the NRC and associated with government business. So again, that's a broad definition that's consistent with the standards in FOIA. And at the bottom of this slide, there are some references to guidance. If you have the slide deck, I think that'll be published. Those are links to various important NRC guidance documents in this area. But and we'll talk about them as they come up in the rest of the presentation. Next slide. So a quick overview of 2390. Again, it establishes that presumption of disclosure for documents that are sent to the NRC for licensing and rulemaking purposes, unless there's a compelling basis for non-disclosure. And the standard FOIA exemptions are listed in 2390, and 2390A4 is the one that corresponds to FOIA Exemption 4, which is trade secrets and commercial financial information, or commercial or financial information. And we'll talk about the process within the regulation as well. Next slide. So the basic requirements for withholding proprietary information. These are fairly detailed, and in some ways they're more stringent than what you might be familiar with in other US government agencies, or maybe other agencies in other countries as well. They are fairly detailed. The basic requirements that we're going to go through in the subsequent slides are things like how documents need to be marked, bracketing and redaction of information, the affidavit for supporting the withholding of proprietary information, which the NRC requires, and then a non-proprietary version. Typically, if you're going to be submitting a detailed technical report for licensing purposes that is proprietary, the NRC will also require a non-proprietary redacted version to be submitted along with your full proprietary version. There are situations where documents may be entirely proprietary or where a redacted version would have no value to the public. Those are exceptions. And if you take that position, you may see some pushback from the NRC on how you're treating your documents. And why do you have to do this? For the reasons described here, you want to prevent the inadvertent release of proprietary information. So if you send something to the NRC, they may very well put it on Adams. So you want to label it. You want to follow these processes, demonstrate the legitimacy and explain why your document is proprietary and should be withheld, so that the NRC has a basis to withhold it. Next slide. So talking about marking and bracketing as well. So this quote here is from 2003 rulemaking, not to enforce a standard of rigidity for its own sake. So you know, these are detailed and you know, they should be followed and are followed. As far as markings go, the basic requirement is to label every page of your proprietary document with something prominent on the page that identifies it as proprietary. The rule talks about something substantially similar to these statements below: confidential information submitted under 2390 or proprietary. At Westinghouse, we mark our documents as Westinghouse Proprietary Class 2, which indicates that they're non-public documents that have been submitted typically to the NRC or another regulator. Next slide. So this page shows an example of the bracketing and marking of a non-proprietary version of a technical report. So the subject matter isn't all that important. It's what's shown in terms of the markings. So at the top, and hopefully you can see this, it shows Westinghouse non-proprietary Class 3 on the top, and that indicates that it is a public redacted version of a proprietary document. And then you can see the brackets and the redacted proprietary information that are on the page. And after each set of brackets, there are a couple of small letters, and those letters, or a number of small letters, one or more, and those correspond to specific paragraphs in the standard Westinghouse affidavit that identify the basis for withholding that particular sentence, paragraph, etc., from disclosure. Those letters are unique to the Westinghouse standard affidavit. Other companies use a similar scheme where they have their own standards and explanations in their own affidavits. So you can find many examples of this on Adams of of publicly available redacted technical reports that show how the affidavits look and how a redacted version of the report is prepared. So next slide. So the affidavit requirements in 2390 B1. Again, this affidavit requirement is more stringent than some other agencies. You'll see the photo on the right. This is not what you have to do. You don't have to go to the NRC and swear that your information is proprietary. This is just a photo of a couple of former commissioners. But to kind of summarize what's in the affidavit requirements, the affidavit must go with the submittal. It has to be executed by the owner of the information. And what that means in practice is that if the licensee or the customer of the vendor, for example, is submitting licensing documentation with a vendor's proprietary information, they can't be the affidavit signer. The licensee, the customer, doesn't own that proprietary information, so they can't submit the affidavit. It has to be an affidavit from the owner, in this case, the vendor. So that's an important detail to keep in mind. The signer must be an officer or upper level management official who's been specifically delegated and authorized to apply for withholding. So in Westinghouse, we have a designation letter that identifies those individuals who are authorized, and those individuals are all trained to understand their responsibilities. No oath or affirmation notarization requirement. So this statute that I've called out here, 28 U.S. Code 1746, basically allows you to dispense with the notary process. If you use the magic words in this statute, that I affirm under penalty of perjury that the foregoing is true and correct, then you don't need to have it notarized. But the affidavit signer must have either knowledge of the content and why it's proprietary, be able to explain that, or knowledge of the criteria or the procedures that the company uses to make that determination. And what that means and what that allows is you don't have to have a technical expert be the one who signs the affidavit. That the authorized signer can consult with the technical experts, understands the process, understands how the proprietary information was identified and segregated, and can sign that affidavit. Next slide. So what goes in the affidavit is kind of listed here as set forth in the regulation. Much of this information is fairly basic. The last piece is probably the most important, which is a full statement of the reason for claiming the information is proprietary, addressing the specific factors in 2390B4, which are on the next slide. So the B4 factors, this is not an and list. So if you don't meet each and every one of these, you still may be able to make a showing that your document is proprietary and it should be withheld. That's still possible. Clearly, the best practice is to explain why, explain each of these factors, address each of them, and explain why your document is, meets as many of these factors as you can. So basically, first, has it been held in confidence? Have you kept it secret? Is it of the type you've customarily held in confidence? Was it transmitted to and received by the commission in confidence? And there, sometimes you get a situation where the commission, the NRC, received the information outside of your transmittal and your affidavit in a formal correspondence. It could be that somebody gave that document to the NRC as an allegor, and now so the NRC has it. There's a FOIA request, and now the company is being asked to explain and demonstrate that that document is in fact proprietary. So you may be in a situation where you don't know how it was transmitted to and received by the commission. So that happens, and you have to explain that. Information not available in public sources. Obviously, if it was available to the public, it'd be hard to claim that it was proprietary. And then the final factor is that the public disclosure of that information is likely to cause substantial harm to the competitive position of the company. That's probably the most stringent factor, traditionally the most important one. But some of you may be asking, why is there a picture of the Supreme Court on this slide? Fairly recently, in 2019, there was a Supreme Court decision that held that the traditional test of substantial competitive harm and the need to demonstrate that under FOIA, that test really didn't come from the statute. And that was a judicially created test many decades ago by a lower court. And the Supreme Court held that test wasn't necessary under the statute. So that's the Supreme Court's holding as an interpretation of FOIA. The NRC's rules haven't changed, they're still in place. So for the time being, it may be prudent to continue to address this factor. Next slide. So this slide summarizes the review process for a withholding request. The NRC will review the request and the affidavit and the package. They have denied requests because information was already available to the public, or it was not, the company didn't actually hold it in confidence. So that has happened. There's no obligation to review unmarked documents or information. So that I think puts a premium not only on reviewing documents when you transmit them, but also internal to the company, right? It's good practice to label your documents appropriately inside the company. So if for whatever other reason the NRC obtains your documents, at least they're marked, and the NRC knows to ask the question of you. There is, if the NRC determines that they disagree with you and they're going to disclose information that you've asserted is proprietary, they give you written notice and an opportunity to respond, and then written notice of any final decision. Next slide. So there's a balancing test in the rule. The NRC reserves the right to disclose your proprietary information if it determines that the right of the public to be fully apprised of the basis for the NRC's decision outweighs your commercial interest. That's a balancing test that has been challenged in the past. In the 1970s, my predecessors in ancient times at Westinghouse challenged that in court, and the balancing test was upheld, and that is still in place. It is theoretically possible for the NRC to decide that the proprietary information you've submitted is so important that even though we agree with you it's proprietary, it may need to be disclosed. But this quote here in the last bullet is from a rulemaking where the NRC stresses that it has rarely, if ever, released proprietary information over the objection of the submitter. But of course, that statement, it should be emphasized, right, that assumes that the NRC has agreed that it is proprietary information. There are many cases where the NRC has challenged that particular information really is proprietary. Next slide. So after you submit your documents and affidavit, if you know what can happen to it if the request is denied? Can you withdraw it? So one portion of the rule says if a request for withholding is denied, the document will not be returned to the submitter. But the very next provision in the rule says if you ask to withdraw the document, then it will be returned to you, unless it forms the basis of an already determined official agency action, or it has been requested under FOIA already, or if it's part of an ongoing OI investigation. So I think these rules are consistent. I think the point is that if the document isn't being used by the NRC for the basis of its action, or it hasn't been requested for another reason, you can get it back if the NRC denies your withholding request. And typically, you will get 30 days to withdraw your document if the NRC makes a decision to deny your withholding request. So that's the last slide that I have on proprietary information. So let's go to the next slide and start talking about other types of information. And fundamentally, when we talk about these other types of information, I think that it's important to make this distinction that's in the takeaway box at the bottom here. So proprietary information belongs to you, or belongs to the vendor or the company who owns that proprietary information. So it's your burden to go through the steps that you need to take to make sure the NRC is on notice and understands the basis for withholding that information from the public. On the other hand, these other types of information are much more of a shared responsibility. It's in the NRC's interest just as much as yours, or maybe even more so in the NRC's interest, to make sure that these other types of documents are not disclosed to the public. So what are those other types? Classified information is probably the most sensitive information that can come up. The Atomic Energy Act identifies certain types of classified information, information related to the design would compromise, or because compromise would assist in the design, manufacture, and utilization of nuclear weapons. Clearly, that implicates some pretty strong national security interests. Also, information about uncompensated security vulnerabilities, that could be classified information. And consistent with standard processes throughout the government, you need to have a clearance to the level of that classification and a need to know to access that information. And the NRC authorizes clearances to some licensees under its regulations. Below the level of, and classified information, I would say, rarely comes up in the licensing context, although it can occasionally. Safeguards information would be the next step below classified, and then SUNSI would be below that, and we'll talk about each of those in turn. So next slide. So safeguards information. In a lot of ways, although safeguards is technically below the level of classified information, it is handled in a manner similar to classified information. So the SGI is secured, kept in a secure location. It's only those who have been cleared and authorized access to access it can see it. And there needs to be a need to know as well. And the rules for SGI are set out in Part 73. And these are the types of things listed on the last three bullets here that might qualify as safeguards information. So things like control and accounting procedures for the physical protection of special nuclear material, and security measures for the protection of vital plant equipment. Those would be considered safeguards information. Next slide. SUNSI is the next and last category of non-public information that we'll talk about. So basically anything that's not classified or safeguards, but yet is non-public would be called SUNSI. So that includes proprietary information. Technically, proprietary information is SUNSI, but there are other categories as well. So privacy information, information from confidential sources, and security-related SUNSI. So that is basically information that doesn't reach the level of safeguards, but yet is related to security of special nuclear material or the facility. And the guidance for security-related SUNSI is in this RIS. There's a link to it in the presentation. That RIS has been updated since 2005, so revision 1, which I think is 2017. And so this RIS encourages the identification and marking of SUNSI materials when you transmit it to the NRC. They encourage you to mark it along the lines described here. They ask you to black out, the NRC asks you to black out security-related information in any public versions of documents, encourages the implementation of internal controls so that at least the folks who have access to SUNSI within the company have a need to know and have been vetted. And then there's a lot of discussion of how do you identify what is security-related SUNSI. This is guidance. This is not a rule, but certainly, as with most NRC guidance, prudent to be familiar with it and make sure that you follow it. Next slide. All right, so this is my last slide. Talk a little bit about confidential information in the hearing process, and building a little bit on what Stephen covered earlier. So in general, as I think Stephen mentioned, hearing requests are based on public information. So the intervener who is making the hearing request needs to review the extensive public information that is typically available on the NRC docket and base their hearing request on that. But after a hearing is granted, the board, the Atomic Safety and Licensing Board, will often issue protective orders covering confidential information that may be needed for the hearing process, either disclosed by the parties and used in the hearing. So that would include proprietary information, if that's at issue, could include SUNSI, safeguards, or personal privacy information. Those are all topics that may be covered in a protective order. A couple of details that I would just mention, as you know, it may be good to be familiar with some of the history here. In 2015, there was a challenge by the state of New York in the Indian Point license renewal proceeding. The state of New York received a large number of Westinghouse proprietary documents through discovery, through the disclosure process. And the state argued that certain of those documents were not in fact proprietary, that they were, that similar information had been published elsewhere. And they also argued that these documents were so important to the licensing process that they should be disclosed to the public. The board did not agree with the state of New York in that case. They found that the Westinghouse proprietary documents had been adequately covered and explained through the affidavit, the basis for why they were proprietary, and that the state of New York, had access to all these documents so they could put on their case in the licensing hearing to the extent they needed to, without disclosing everything to the public. So it's an important decision in this area. And then finally, I think it's worth mentioning that there are special procedures that the NRC has put in place to access safeguards information in ITAC hearings for combined licenses. Those are the ITAC hearings that Stephen talked about. So there is an opportunity for prospective interveners in ITAC proceedings to seek access, seek pre-clearance to access safeguards information for the purpose of developing their contentions. So they need to show that they will have standing, that the group, the intervener group, will have standing, or is likely to have standing, and that they have a need to know that they need this information to prepare their case, and that the individuals who will access it are appropriately trustworthy and reliable. And then all the other requirements in Part 73 do apply for the control of safeguards information. In the ITAC hearings that have been held or noticed so far, there weren't any requests for pre-clearance to access safeguards information. So, but that's something to keep in mind to the extent you're going to be using the Part 52 process. So that concludes my presentation. Happy to take questions on any aspect of this. And I think I'll be turning it back over to either Jim or Chris.
Chris, you can go ahead and get started. And again, as a reminder to everyone on the line, please send any questions you have to us through the questions box that's available there in the webinar. Again, we're collecting those up and we'll plan to go through those at the end of the session. Thanks very much.
Perfect, thanks so much. And you can go to the next slide. So my name is Chris Nolan. I'm the Vice President of Regulatory Affairs, Policy and Emergency Preparedness for Duke Energy. And I'm happy to be here today to talk to you a little bit about how we're positioning for climate change and advanced reactors to bring value to our customers. So I started my career similar to Stephen at the Knowles Atomic Power Lab as a General Electric employee in prototype operations for the Navy nuclear program. That was a fun job. Then for about 9 years, I was a design engineer at Calvert Cliffs working for Baltimore Gas and Electric. And then for about 9 years, I worked at the Nuclear Regulatory Commission in the Office of Nuclear Reactor Regulation, Office of Enforcement, and Nuclear Security and Incident Response. I started my NRC career as a project manager, and I ended it as a branch chief in the environmental program for new reactors. I joined Duke in about 2006, and I've been in the operating fleet since about 2010 in various versions of my current role. Prior to that, I was involved in the William States Lee combined operating license that Stephen listed as one of the AP 1000 licenses that was issued by the staff. We still are keeping it active, but we haven't done any construction on the site. And so hopefully I can give you an owner-operator perspective and what we're doing to position ourselves for the future. Next slide. So I introduced myself, so now let me introduce Duke Energy. So we're the largest regulated utility. We operate in 6 sites, including Indiana, Ohio, Kentucky, North Carolina, South Carolina, and Florida. We have 51,000 megawatts of generation, of which 11,000 of that is nuclear. We also have a strategic combination with Piedmont Natural Gas that we did a number of years ago, recognizing the importance of natural gas and decarbonization. And we also have a relatively large renewable profile that's across the country. Next slide. Introducing our nuclear fleet. So we have 11 units at 6 sites. That's roughly 11,000 megawatts. We generate more than 50% of the electricity used in the Carolinas. We generate more than 84% of the carbon-free energy across our entire 6-state enterprise. And when we talk about our nuclear fleet, we talk about it in terms of today, tomorrow, and the future. And today is operational excellence. What do we do to operate our plants as efficiently and safely as possible to ensure their viability into the future? And how do we make them as competitive with other sources of generation like coal and natural gas as we can? Tomorrow is subsequent license renewal. How do we renew the licenses for all of our units to operate into the mid-century? And we plan to submit our subsequent license renewal application for Oconee this summer, and then follow through the rest of our fleet based on their sequence based on the age. And then the future is advanced reactors, the attractiveness of the low pressure, which improves safety characteristics, and the high temperature, which improves efficiency and offers opportunities like thermal storage or hydrogen generation are very attractive to us and bringing value to our customers. And I'll explain why in a later slide. If you go to the next slide, you'll see this is our wind and solar portfolio. And this really tells a story of storage, although it's not really that obvious. So wind and solar are intermittent generators. They don't always generate the power when you need it, and sometimes they provide power when you don't. If you look at the Carolinas, we have a peak in the morning and in the evening, and a lull in between in the middle of the day. We're the number 3 solar producing state in the country in North Carolina. So that solar brings us power between 10 and 2 on sunny days. And so what do you do with that power? Because it starts coming on when our morning peak goes away, and it starts going away when our evening peak is ramping up. So we have pump storage facilities on our system, and we've changed the way we operate them. So we pump in the middle of the day and let down in the evening to take advantage of it. But we're highly focused on batteries. We're also highly focused on thermal storage as an alternative, because if you can, and we're also highly focused on flexible operations of our baseload plants, because if you can integrate those 3 things together, you bring more value to all of those assets. Next slide. So the current administration under President Biden is very focused on clean energy and is creating a lot of momentum. And some of that momentum is out in front of reality, but there's 3 things that are really important on this slide as a takeaway. One is advanced nuclear, the opportunities for greater flexibility by the ability to produce electricity or store energy thermally, or produce electricity or generate hydrogen. The target date of 2035 for carbon-free for the utility sector, that's a very aggressive date, and there's policy issues between where we are and that date, and cost and technology are 2 of the issues that are there. And then the new term that we've created, which is zero emitting load following resource. And what that really gets to is that, when we operate our nuclear plants, we'll have a 30-day refueling outage, and then we'll operate based on the plant design between 18 and 24 months, 24/7, and then shut down and refuel. As we bring more and more solar and wind onto the system, there are going to be times where nuclear, wind, and solar are more than our customers demand. And so what power source do you back down? And our current operating fleet, we can load follow, but it requires a lot of water, and we don't have ramp rates that are as fast as some of the power changes that we see on our system. So that creates a challenge and an opportunity for the future. Next slide. So our carbon goals. So Duke as a company is committed to have a 50% emissions reduction by 2030. We're largely accomplishing that, and we'll meet those goals early. And we're doing it by the continued operation of our nuclear fleet, as well as a transition from coal to natural gas. And that has provided tremendous value to our customers because it reduces our carbon footprint, and it also brings our customers a low-cost product. Our 2050 goal is net zero, and net zero is a much tougher lift because it will require us to move away from natural gas, and what that something is that we move to is really up for consideration. We believe it's going to be nuclear, but we also recognize that new nuclear is going to have a cost impact, and our customers care about the environment, but they're very much focused on cost, and so that is a policy barrier that we have to work our way through to be successful. Next slide. So this is just a picture of our generation mix, both historical and projections into the future. We do integrated resource plan modeling, and we submit them to our utility commissions every 2 years. And we've learned a couple things in the modeling, and one is that we can't get to net zero 2050 unless we have our existing nuclear fleet continues to operate. So that means subsequent license renewal is important. You have to have a fuel, and right now the only viable fuel we see is nuclear. And it's really a challenge. And so if you look at 2005, 60% of our generation was from coal or oil. And if you look at 2050, it's zero, right? And so what changed to take up that significant portion of the generation mix? Well, if you look at nuclear stays the same. So, the percentages vary from here to there, but really that's a change in the overall load, not the change in the nuclear fleet itself. And when you look at natural gas in 2005, it was largely just peaking units, and it's 6% of our generation. 2019 is 33%. It's projected to go to 41% by 2030, and then down to 6% by 2050. Hydro stays the same. So the variations of 1, 5, 19, and 36% is really the penetration of wind and solar. And then in 2050, you see this new term, the ZELFR, the load, the zero emitting load following resource that we expect will be advanced nuclear, with a combination of either storage or hydrogen generation, so it can integrate better with wind and solar. So that's where we see the future to be, and that's where we're positioning to meet our needs. So really, in the next slide, we're going to start talking about how we're going to accomplish this goal. And so when I talk about project risk, what I'm really talking about is the timeline over which dollars are spent. So the way we do cost recovery in a regulated utility is that when we spend money on a capital project, we put it in an account, we finance it with debt and equity, we pay interest on the debt, and And when that project goes into service, then we put that capital investment into the rate base and charge the customers for it and depreciate that over the life of the investment. And so what that means for a large project like a nuclear project, the goal is to have that project be as short as possible and time the significant investments towards the end so the finance charges don't become a significant portion. And so in doing that, we look at the siting risk, the technical risk, and the regulatory risk. And the siting risks are substantial, and what they are is really where's the plant going to be located, outreach to the community, the local, state, and federal entities that have interface and jurisdiction, the environmental impact statement, and then the hearing process and any intervention that could come from that. And so those risks are significant. The technical risks are really, is the technology ready? Is the detailed design ready? And are there going to be challenges along the way with how to construct it and delays? And then the regulatory risks are, Stephen's presentation on the hearing process was excellent. Everyone should get a copy of that presentation to hold on to it, because he went through all the processes very well and then talked about the hearing I've not seen a better overview of that complicated process. But when I hear hearing, I think it's expensive, it takes a long time, and the outcome is uncertain. And having the hearing at the end of the process, when you have a significant cash outlay and you're accruing interest on it, is a high risk dynamic. And so when you look at this, what we're really looking for is environmental finality, design finality, and regulatory finality. And I'll just go to the recent examples that we have with AP 1000. So, the Vogtle plant with Southern, the Summer plant with SCANA, and the William States Lee plant at Duke, we all submitted our applications at about the same time. In fact, Duke submitted a William States Lee application first, and of the three, I think second in the industry. And both Summer and SCANA, their reviews were about 4-year reviews, and our review was a 9-year review. And the difference really was SCANA and Summer signed ECP contracts and were spending money on long lead items. And so the NRC was motivated to complete those reviews. And in any regulatory decision, there's 3 possible outcomes, right? Yes, no, and delay. And delay can look like a no if you're financing significant resources over a long period of time. And so the delays in the William States Lee application really came from Fukushima and changes in the seismic source model. Because we weren't making significant capital investments at the time, the staff took a very conservative approach, and we spent a number of years responding to questions associated with those. And so our application took 9 years to get approved. And so the regulatory risks are real, and the process that you pick can impact those. So we'll go to the next slide and start talking about the processes. So the early site permit is an excellent risk reduction tool. It can be approved in advance of any decision to build or technology selection. It's good for 20 years. It can be renewed for up to 10 to 20 years. If you use the plant parameter envelope, you can bound the early site permit to include multiple technologies, so you don't lock in with a specific vendor early and limit your flexibility. And it allows you to make progress in the licensing arena and reduce risk while the technology continues to advance and develop. And, when you go to the hearing process, the NRC is a very competent, thorough, and effective regulator. And they rarely are wrong on safety issues, and they get significant deference from the court. And their hearing process is very robust. In the environmental area, there are lots of experts, and so we see the environmental risk is a higher risk appetite or a risk component. And then when you look at siting, seismic is another area where there are a lot of experts. And so the early site permit gives you the opportunity to get finality on some seismic issues, and also the environmental issues are very attractive. If you have a limited work authorization, it allows you to do some amount of site preparation while the NRC is reviewing an operating license. And we find it as an excellent tool for risk mitigation. One of the challenges for a utility like mine is that while you can do it early, and it provides its most benefit if you do it well in advance, the idea of getting cost recovery on that is still a dynamic, right? So you don't really, under the current rules, get to recover costs for an early site permit until a plant is built and placed online. And so those are one of the policy issues that we're looking at closely when we look at advanced reactors. Next slide. So the Part 50 licensing process, it's been called a two-step process, but really what it does is it allows you to pursue with field work, design work, and regulatory approvals all concurrently. And so if you want to get to the finish line the fastest, that's the process to use. One of the disadvantages is if you don't make it to the finish line, you have the highest amount of stranded investment. And so if I just look at Duke, we have 3 reactor projects that we stopped in the mid-80s. One was from our predecessor company, Public Service Company of Indiana at Marble Hill. Construction started in 77, it terminated in 84, $2.6 billion of stranded investment. That would be about $9 billion in today's money. Zimmer was from Cincinnati Gas and Electric, started in 72, suspended in 84, $3.1 billion. If you look at the Cherokee site in Gaffney, Carolina, it's the site we went back to for William States Lee. We suspended that in 82, $633 million. If you add those 3 sites together, that's in today's dollars, that's about $20 billion of stranded investment. So Part 50 can be expensive if you don't finish. And Part 52 was really designed as an alternative to Part 50 to mitigate those risks. And if you go to the next slide, the advantage with Part 50 is it puts the design review and the operating license review in series, in that you have the opportunity to go for your operating license when you have design finality or detailed design, which makes the licensing process go the smoothest. If you combine that with an ESP, you've already got environmental finality. And so it reduces a lot of the regulatory risks early, and it puts the hearing process in advance of the site construction activities. The disadvantage is if you don't have the detailed design finished and you try to change it while you're constructing, you're in a licensing process to do those changes. The other is the detailed design needs to be well along for you to do it, which means it takes longer to accomplish. And really, if you look at risk sharing between the technology vendor and the owner operator in the Part 50, the utility bears a significant amount of the risk. In Part 52, the vendor bears significant amount of the risk early, and the utilities risk comes in later when there is more certainty. And so really, when you talk about first of a kind and next of a kind, the first of a kind plants are focused on when they can be finished. They have government support, which is very important, and they have a significant amount of risk associated with the process. I see some of the next of a kinds going more towards the Part 50 route, since after the initial plan is built, the detailed design should be pretty farly worked out. If you go to the next slide. when you go to advanced nuclear implications, there really is a significant opportunity in front of us to learn from our experiences in the 70s and 80s and learn from experiences, in 2005 to 2008. And one of the biggest lessons learned that I took away is that the economic cycle that is advantageous from a business case standpoint from a nuclear plant construction is limited in time, right? In 2007, we saw very high gas prices, and so a nuclear plant looked economic. In 2010, 11, 12, the price of gas dropped, and you saw a lot of projects either suspend, terminate, or like us at the Williams States Lee, we have the license, but we didn't go to the construction phase. And so really the challenge for the owner operator is to be ready to start and finish construction while the economic cycle is favorable to the business case, in which means you have to eliminate as much of the licensing and technical risk you can in advance. And so that's really how we approach the licensing process and how we value it at Duke. We have some experiences from the 70s and 80s, many of them successful, some not. And we have some experiences from the last decade where we learned a lot. We have our Sharon Harris application is still with the NRC and is in a suspended state. We also had an AP 1000 combined operating license approved for our Levy site in Florida. We wound up terminating that license. And so, the future is very exciting for nuclear, and we have lots of lessons to be learned from the past. But one of the critical lessons is the importance of the government's role in risk mitigation for the early deployments, so that companies like mine can springboard off that and come up with commercially viable products that can add value to our customers in the future. That's all I have.
Thanks very much. So thanks very much again, Stephen, Ray, and Chris, for all of the insights. As I mentioned at the beginning, I'd encourage you all to send any questions you have for our three speakers. We have a few in the mix there, but please continue to send those on as I work through a little bit of wrap-up material here. Again, I'm going to take about 20 minutes or so and just hit a few of the highlights from webinars 1 and 2. I'll go through this pretty quickly. Again, the recorded material from those webinars, if you'd like to drill down on any of that content, is available on the GAIN website, as well as the slides that were presented at that time. So again, send us your questions and we'll come around to those after I finish with my wrap up, and we'll go back around to the speakers. Before we get started, just some brief background. I've been in the nuclear industry for about 40 years, about 30 of that on the commercial side, primarily with boiling water reactors. Was involved with the licensing of the GE ESBWR. And then for the last 10 or 12 years, I've been working in the regulatory affairs area with the Department of Energy and the industry through a position at the Idaho National Laboratory, primarily focused on identifying and addressing and resolving some of the regulatory and policy uncertainties and issues that present themselves for advanced, primarily non-water reactors. Next slide, please. So again, if I go back to our webinar number 1, if you may remember, for those of you who participated, that was focused primarily on some of the early days of history. It covered nominally from I'll call it the early 50s to the mid 80s and a little bit beyond. We talked about in that session how nuclear energy was developed in the first place. We talked a bit about how the NRC framework came together, and then how that framework developed during that time came to be what it is today, along with some of the issues and challenges and opportunities that it provides. Next slide. So if we go back to the earliest of the early days in the Atomic Energy Act, and then its update in 1954, we were primarily in a weapons development peak of the Cold War period. And so as we were moving into the 50s, much of the focus of nuclear development or nuclear power development was on how you can make primarily naval propulsion systems that can move weapons platforms around. And so the nuclear Navy was working on various options there. They were looking, as we talked about in that session, they were looking at a couple of different technologies, predominantly pressurized water reactors and sodium reactors, although there were a few others that were in play. And again, that was the primary focus during that period of time. But it was recognized around that same time, in the mid-50s timeframe, that we wanted to move into this atoms for peace concept. And so there was some amount of, I'll call it disarray at the time, or, as this slide refers to, unaligned agendas where the executive branch, the Congress, National Security Council, the AEC, and the private sector all had some different opinions on how things ought to move forward. And so some of that history is important. There are maybe some lessons learned there, or some parallels with today's structure. But again, I just wanted to remind you of that summary if you'd like to look at it in more detail. Next slide. So again, there were a number of parallels in that 50s, 60s, early 70s timeframe. There were a lot of discussions and a lot of evaluations ongoing around which technologies were the ones that were going to turn out to be the most economic and reliable, kind of to a couple of the points that Chris was just making. There were some questions about whether nuclear would be economically competitive at all. There was one end of the spectrum with the too cheap to meter concept, and then others who were a little less sure that we would get to that place. There were some issues and challenges with technical information and how it was managed and made available. There were questions around whether the US government should be working to commercialize focused only on the continent, or if it should be looking at things more globally than that. And again, there were a lot of issues at that time around public-private investment and what the right mix ought to be. And an overlay behind all of that was there wasn't a clearly developed regulatory framework, including licensing process and processes and export controls. So some parallels to some of the challenges we face today, although at a much more significant level back in the day. Next slide. So the Atomic Energy Commission, again, as a reminder from that first session, went through a series of power demonstration reactor programs. I won't go through all of these, but there were a number of technologies that were evaluated, built, and demonstrated or tested. As this program went on, it tended to move more towards the direction of the pressurized and boiling water reactor technology types. Next slide. And then the first U.S. large-scale nuclear plant, as you see in the lower left there, was the shipping port reactor. That was actually developed by the Office of Naval Reactors in a partnership with a private utility, Duquesne Light. It was based on the propulsion system and reactor system for an aircraft carrier that was under development at the time. And it was developed in a partnership with, I think it was Westinghouse, Stone & Webster, and Burns & Rowe at the time. Came online in 1957, and it was, I believe, around 60 megawatts electric. So that was the first result of a public-private government partnership with a reactor that was put on the grid. So that was the first large-scale nuclear plant. Next slide. So as we were moving from that transition from Office of Naval Reactors, who were continuing with their role in developing technologies and nuclear propulsion systems for the Department of Defense, then the commercial sector began to emerge. And again, that was as we were moving from the mid-50s through the mid-70s. And if you recall, we talked about, and I think Roger Madsen, if you recall, talked in some detail about the three major eras that we envision, or that we have some experience with, and how the current regulatory framework came together. So again, in that 20-year period that was basically mid-50s to mid-70s, again, there were a number of players with a number of different missions and opinions for how things should move forward. So I think, as you remember in that first session, we labeled that the searching for the regulator's role in that whole mix. With the Energy Reorganization Act of 1974, the Atomic Energy Agency, or Atomic Energy Commission, split the Department of Energy off from the Nuclear Regulatory Commission after recognizing that it put the organization in a difficult spot to be both the promoter of the industry as well as its regulator. So again, the NRC came into being in the 74 timeframe, and over the next 5 years or so, you see there 75 to 79, they were beginning to establish their regulatory requirements within NRC. And again, kind of getting back to one of the themes Chris mentioned, there were a number of utilities that had construction projects either underway and that were well along, or that were getting started on construction projects. So that development of the requirements in parallel with with those projects ongoing became a critical issue that we'll talk about in a minute. And then when we got to 1979 and a few topics beyond, the opportunities to build in operational experience came into the mix. Next slide. So again, as I mentioned, in the first mode of this, first watershed era, we had the Atomic Energy Commission that was being split into NRC and DOE. As we moved into the NRC's effort to develop itself as an independent regulator, as I said, there were a number of projects that were already well along. And so the industry started to move into a sort of a flavor or an approach of NRC, just tell us what you want rather than us working that out together, because we just don't have the we don't have the opportunity to spend a lot of time in sorting out what the rules ought to be. So rather than us debating how they should be formulated, let's move more towards a mode of just tell us what you want so that we can apply those rules and move on and get done with our projects. And that tended to create this paradigm that I know we spent a little time on in that session of, if the NRC establishes all of the requirements and we comply with them, then we've accomplished our mission and we have a safe reactor, which again, we'll talk about in a minute, but it's really more of a shared responsibility and understanding. And then again, as we move forward into the late 70s and early 80s, there were a number of weaknesses or areas that maybe weren't fully considered during that second stage in the watershed period, including things like operating practices, or materials may have been selected that weren't as resilient as they needed to be for multiple year operation, and that wasn't clearly understood in the early days. Issues with personnel training. And so again, the industry put a lot of focus on those areas and making improvements both to improve overall safety of the facilities, but also to improve their capacity factors and make them more economically viable. So it was in that time frame that the Institute for Nuclear Power Operations came to be, and the industry put a lot more effort into, I'll call it self-regulating and self-improvement programs and projects. Next slide. So again, I talked a little bit about this, just tell us what you want concept as NRC was developing its material. Again, this is focused primarily on the period that was in the late 70s. There was a lot of pressure on both sides of the table in doing a complete job, but getting licensing done and off the critical path. so that construction could be completed and operation could begin. And then as we moved through the 3 Mile Island accident, there was a bit of a reversal of that approach. But at that point, the pendulum had swung pretty far. I think most folks would agree the pendulum had swung pretty far to the point where NRC was generating a lot of requirements with limited involvement or engagement from, or pushback, I'll call it, from the industry. Next slide. So I mentioned again, we went through a series of learning experiences, starting with Browns Ferry fire in the mid-70s. We're familiar with many of these. There was the event at Salem that was a precursor to the anticipated transient without scram transient. The Davis-Besse loss of feed water event, Davis-Besse head issue, and then I think we're familiar with Chernobyl and Fukushima. The other thing I'll mention that is in the 80s and 90s, there were quite a number of plants that were on the troubled plant or the watch list. Many of those issues had to do with designs that were that had some weaknesses or areas of improvement that needed to be further evaluated. And many of those challenges came from operating configurations or maintenance challenges that maybe weren't fully thought out, either when the plant was designed or as it was being operated. And so as those events occurred, the general response from NRC and industry was to make sure that we understood each of them, but they tended to then add additional regulatory requirements and or regulatory guidance to address the kinds of things that occurred in each of those events. So that added to the existing regulatory framework that was already in place there in the late 70s. Next slide. So because that regulatory framework came together basically as a combination of the first cut at the rules that occurred in the late 70s, and then all of the modifications or expansions or improvements to the rules that occurred as operating experience was gained, we get to a pretty broad set of documents that are closely related, generally consistent with each other, but you have to have a pretty good working knowledge of that whole regime to be able to find your way through it. So it sometimes is given the nickname the regulatory framework patchwork. And when we talk about the framework, as we discussed in that session, it really comes from 4 primary areas. There are commission policy and the related authorizing language, and the regulations, technology-specific licensing requirements for individual reactor types or approaches, and then the license application, development, review, and approval processes, which are the ones that we covered primarily today. Generally serve the industry pretty well, but again, there are some opportunities to make it more efficient going forward. But again, we hope that session number 1 helped you to understand how the existing framework / patchwork came to be what it is. Next slide. I guess the key in moving forward, and this will sound simpler than it sometimes is in practice, is even though this patchwork is pretty large and complex, and it tends to be focused by its nature on large light water reactors, typically the best or the most efficient way to find your way through it in an advanced reactor technology is to develop a very strong safety case first with a very robust design, and then sort out a path through the licensing process. So, as noted in some of those sub-bullets there, again, history always seems to show that if you start with a robust safety case that starts out by, again, including significant safety margin, while also meeting the needs of the owner operator or the end user, best place to start. And as you move through that story, you can package it in a way that addresses the associated NRC requirements with margin. And when we talk about robust safety, particularly with advanced reactors, we tend to mean reactor designs that have a number of inherent and intrinsically safe features. So they require limited operator or active component interaction. They generally have a lot of margin between the operating practices that will be entailed with the implementation and where the design can allow them to go. And they tend to be very well designed against common mode failures or upset conditions that could bring those kinds of challenges into play. The things to keep in mind, again, in the when developing and designing and licensing on the front end is, as folks mentioned earlier today, licenses are issued for 40 years, and many are being extended to as many as 80 years, on the horizon. So, need to keep those long-range considerations in mind, including material degradations and maintenance programs. The other thing to keep in mind is that over that many years, depending on the design of the plant, how it's operated, it could be placed in a lot of different kinds of configurations that may not have been fully contemplated up front. So we'd always keep those kinds of topics in mind. Next slide.
10 minutes, Jim.
Okay, thanks. And then the other thing that we talked about is in that 1970s and 80s period, in the just tell us what you want kind of an approach, the dialogue started to become pretty much exclusive between the developer and the NRC, with the owner operator kind of being on the fringes and just accepting whatever came out of that dialogue. The problem with that is that the owner operator is ultimately responsible for the reactor and its protection of the public, not the developer. And the owner operator may have insights into how it's planning to actually use the machine that may help to inform or modify some of the insights or the approaches being proposed by the developer. So again, we pushed quite a bit on the theme of making sure that it's a partnership between the owner operator and the developer as we work toward achieving nuclear safety and efficient licensing. Next slide. So this is just a wrap up from some of that past experience. Again, this is from the first webinar. I won't repeat any of this, but I did mention, as I said, that the owners have not, at least during those early days, been as demanding or involved as they maybe should have or could have been to move those early generation 1, 2, and 3 designs forward. We now have 17,000-ish reactor years of operating experience around the globe. And as we work to move forward with advanced reactor technologies, we need to be sure that we don't get back into the mode of developers and NRC being the only organizations at the table. Next slide. So in webinar number 2, after we covered those early days, we kind of peeled back the onion a little bit and looked more at just what's inside of this regulatory framework. How can you find your way around inside those various document types? How can you exchange information with the NRC? And what kinds of things do you think about when you're establishing a deployment plan or path? Next slide. One of the things we covered in that session was kind of a drill down on key parts of the NRC's organization, including the job of the commission versus the roles and responsibilities of the technical staff. We also spent a little time on the advisory committee on reactor safeguards of the ACRS that I think some of the earlier speakers talked about today, as well as the Atomic Safety and Licensing Board, which I think Stephen spent a little bit of time on. The thing I wanted to highlight here, not that it's all the eggs in one basket, but predominantly for the advanced reactor technology development community, most things center around or start from the Office of Nuclear Reactor Regulation. So that's the box that's highlighted there in the bottom center. Andrea Vale's the current acting director, and that organization is supported by other branches on the tree here, but that's the starting point. With the Office of Research supports them, Security and Safeguards area supports them, but again, that's the starting point. Go to the next slide. It expands on what the Office of NRR looks like. You can see across the bottom all of its key divisions. And the two divisions, again, that are the starting point for much of the dialogue that we're involved with, or that you would be involved with going forward on advanced reactor technologies, are the two that are in the middle. The one on the right, Division of Advanced Reactors and On-Power Production and Utilization Facilities, are the folks that are predominantly establishing the rules or adapting the LWR-based framework and rules so that they can be applied to advanced technologies. And then the green box on the left, the Division of New and Renewed Licenses, are the folks that actually will be reviewing the application types that we talked about today. And then they're supported by the other boxes left and right, the blue ones that are there. You can pretty much discern from the name of the division what kind of work they do. It centers around, most of the interactions start with or center around the two green boxes in the center. Next slide. We also talked about in that second session how we move from the top of this pyramid in the U.S. Constitution and the associated statutes down through what are the actual regulatory requirements, regulation and orders, how do those become license requirements, and things become more specific, obviously, as you move from the top of the pyramid to the bottom. So again, we talked around the structure of the NRC's requirements, and then on the next slide, please. We talked about the various types of NRC guidance documents that have been developed over the years, and these provide different levels of insight into how NRC has reviewed implementation of the regulations in the past. What are some good practices? What are acceptable ways to do things? What kinds of acceptance criteria will they apply whenever you send them an application? So we went through those various document types and what they contain. Next slide. You may recall that in the last session, Ray Sheely from the TVA spent some time talking about regulatory engagement plans, the importance of establishing an interaction plan, both within your own organization and how you'll plan to engage with the NRC. That includes establishing communications, going through a very well-developed pre-application engagement with NRC, both so that they know what's coming to them in your application, and so that you can consider and include particular topics or pieces of information that they may highlight in those pre-application engagements. And the whole purpose of that is to come around to the goal that Chris mentioned, in that you want to minimize the time. Although you want to be thorough, you want to minimize the time that you're in the period of regulatory review and as you move towards the finish line and the issuance of the license. Next slide. So I won't go through all of these bullets, but obviously there are a number of advantages to pre-application engagement, but they all come down to nobody around the table being surprised and generally improved efficiencies. I appreciate the fact that that Chris, from his experience and insight from Duke, helped to identify that the environmental review and some of the siting reviews that are involved tend to be a pretty large portion, maybe even as much as half or more of the overall risk in a regulatory or deployment project. I think we sometimes lose track of that that nuance or that fact, because we spend a lot of our time focused on the reactor design. So I think it's good to keep those things in mind and factor those into pre-application engagements. Next slide. This is the, again, we went through the experience of the Clinch River early site permit. Ray went into a fair amount of detail in that effort. As you may recall, that was one of the first, or the first application that proposed some changes or right sizing of the emergency planning zone that would be required, and made it align with the level of risk that would be potentially coming from the range of facilities that might end up on the Clinch River site. So again, it's a good example of how to develop and implement that kind of an effective NRC engagement. Next slide. So today I won't rehash what we covered. We'll go around to the questions that we received. But again, we talked about licensing pathways and hearing processes. Stephen, I appreciate you highlighting or shining some light on the black box that's referred to as the hearing process, but maybe a lot of folks don't always know what the different types are and what kinds of challenges could be involved there. Chris, both you and Stephen, I think, helped to highlight that both the one-step and the two-step processes have their advantages and disadvantages. They all have to do with where the levels of finality are desired to be and how likely it is that you may need to change a design or change an approach somewhere in the midstream of the process of licensing and deployment. And then Ray covered the ways in which you can use and transmit non-public information. So again, in a minute, we'll switch over and come around to your questions on those topics. Next slide. So that wraps up the series of 3 webinars that we originally had in mind, and they were primarily focused on helping everyone to come to a common understanding of what's the current regulatory framework, how did it come to be, how can you go about implementing it for various reactor technologies, how do the processes work, what are the challenges and pitfalls you ought to be aware of and keep in mind, and again, how can you develop a good regulatory engagement strategy. I think, as you know, there are a number of changes and adaptations underway to further refine the regulatory framework and in particular to make it or to provide some less LWR-centric options going forward so that it can more directly and broadly support other reactor types in a clear and efficient way. So we've, in the first 3 webinars, given you a snapshot of what is. We are planning a 4th webinar. Its current theme, although this title isn't final, is establishing the route to the regulatory future as we work through these various future deployment projects. We expect that this one is going to be based primarily on insights and inputs and presentations from industry stakeholders. And it'll talk a bit about what's in play in those various change and enhancement environments, and with a focus on how we might be able to identify new and different activities and objectives to continue to help moving that process along so that we can make the picture and the path as clear and efficient as possible going forward for stakeholders who may be considering or may be engaged in a future deployment project. If you have any, we have some inputs already for what may go into that webinar. We're still developing that plan. If you have any particular inputs or suggestions, we encourage you to email them to that the address there that's at the bottom of the slide, the Gain Events email. And if you go to the next slide. And then this is my last slide. I did want to remind you, and I put this in each of the first 2 webinars, that in addition to this webinar series, we have an active MOU in place between DOE and NRC associated with the GAIN initiative. If you have issues or questions or concerns about how to navigate the regulatory process, and in particular, if you have questions that are associated with trying to gain a better understanding of some of those pieces of the pie. We're an available resource to help with that, either directly or in consultation with NRC, and can get you to a timely answer to those kinds of questions. Again, you can look for that opportunity to provide questions is on that GAIN website there at the bottom. And the regulatory portion of that GAIN website at the bottom, the GAININL.gov, will also be the place where the slides and the recordings from today's webinar, as well as the first two, will be available. I think that's all I have. And again, we appreciate your participation today. I'd like to now go on to the question and answer period. I saw that we had a few questions before I started to speak. So again, I appreciate it if the participants and the speakers, excuse me, could pop back up. It looks like Stephen and Chris are back, and Ray. So I think one of the questions that I saw before I started to speak was, it was along the lines of, so based on the experience that we've had with implementing Part 52, would a first of a kind developer or designer choose to go down that path, or is it possible to go down that path? I guess my view of that world is, as Chris identified, and Stephen, I think, touched on this as well, you have to do more work up front in that process. And the decision really comes down to where you want to establish and manage risk. And the other key consideration, at least in my mind, and I'll turn it over to the other speakers to get your perspectives, but a key consideration is whether, if you use the one-step Part 52 process, whether the facility you're building is likely to be able to be replicated without any significant changes. If you think units 2, 3, 4, and out through unit 40 are all going to be nominally the same as unit 1, then there are a lot of advantages to that process. If you think you're going to be making changes through the first couple of evolutions, it may not be the perfect choice. But I'll turn it over to maybe Stephen. You want to go first and on your additional perspectives, and then we'll ask for Ray and Chris to weigh in.
Yeah, sure. Thanks, Jim. I think the short answer is yes. That I think definitely, first of a kind advanced reactors can be licensed under Part 52. But inherent in the question is the broader issue of, should it, or how difficult will it be? And I think, I was thinking of this as more from the licensing standpoint, that there certainly are challenges for trying to apply Part 52 to a first of a kind advanced reactor. A lot of the regulations were written, even their words themselves say that they apply to light water reactors. And so there's a lot of work that will have to go into looking at the NRC regulations. And I think companies are doing just that, doing a survey of the NRC regulations and determining, which ones do definitely apply just based on how they're written, which ones, may or may not apply depending on the design, and which ones definitely don't apply. I would say that this is a topic where I think it needs to be looked at pretty early for a company that's thinking about this, and then engaging with the NRC. Certainly, this is a good pre-application conversation with the NRC, because the regulations aren't also clear that it's either yes or no. There's some gray areas. There's things like the general design criteria where, they on as the words say and in the introduction, apply to large light water reactors, but there will have to be something related to advanced reactors. So I think it's doable, but it's going to take some extra work. And I'll say, probably everyone knows this. There's an example of just this happening right now with the Oklo application, and that will be, I think, instructive to all companies to see that engagement between that applicant and the NRC. And let me just correct quickly one thing I said earlier. I was trying to think of of a COL application that didn't rely on a design certification. And Oklo is that example. But I think a lot will be learned from that licensing activity. Thanks.
So just to expand the answer, I think the answer is yes. And you know, the AP1000s at Vogtle 3 and 4 are an example of a first of a kind designs that were implemented under PERT 52. And now one could argue that was an evolution, right? You know, the light water industry's been around for a while. Westinghouse designed AP600 and had a design cert. And AP1000 is an extension of that, a power upgrade of that. And you know, the detailed design wasn't as far as long as everyone had hoped or thought, but clearly it was far enough along to get a combined license, and it looks like Vogtle 3 and 4 are going to be successful, which is important to the industry. I think it's really risk appetite and timing that drive you between Part 50 and Part 52. If you want to get it done as fast as possible, and you have enough partners to risk mitigate, you know, Part 50 is certainly a viable process to construct, design, and license as you go. It's a high risk, but it's the shortest time from beginning to end for all parties included. Part 50, you know, basically brackets the risk between the vendor and the utility, and the experiences in the 70s and 80s were the driver for that, and so from our perspective, that is you know, a better pairing of the risk. And so, you know, the idea that the DOE is supporting you know, the 2 advanced reactor designs in the ARDP is very important to accelerate deployment. And I think the schedules that DOE has laid out is pushing towards Part 50, and with the federal government involved in taking some of the risk, you know, that may be totally appropriate. But you know, a publicly traded utility is not an R&D company, and its job is to get the best value for its customers. And so Part 52 minimizes the risk profile to the utility.
Thanks. Ray, anything you'd like to add on that topic?
I would say certainly agree with Stephen and Chris that the short answer to the question is yes, it is possible to do that. You know, I think the other panelists kind of pretty well summarized the pros and cons of both processes.
Another question we got, and I'll let you all go first, was along the lines of, in some of these processes, we use the term an essentially complete design. There was some question around what does essentially complete mean. I mean, I have a couple of insights on that, but I'll go last this time around. So who'd like to go first?
I can get started, Jim. This is a challenging question, and I think there's a lot of ongoing discussion of what this really means as part of the Part 52 lessons learned rulemaking and other activities to try to refine, you know, what is the right level of detail. You know, this phrase is in Part 52 for design certifications. It's not clearly designed. I think there's some regulatory history with the rulemaking documents that do it. You know, on the one hand, you know, the entirety of the regulations and guidance and precedent, you know, gives some indication as to at least what that's been viewed as in the past. But definitely, you know, as part of this rulemaking process and looking at this again, I think it's a key point. And in some ways, it does tie to this kind of finality questions that we've been talking about. You know, Chris and I both just dug into that a little bit, that there's a trade-off, and, you know, for having more finality for the design, that certainly requires, you know, more design details for what's done in Part 50. And the NRC has to have enough certainly to make its kind of safety conclusions and safety findings. And so there's a balance there, and I think that's just going to have to be worked through to see, you know, are there improvements in areas to refine that. But I'll stop there.
The way I look at it is similar, right? You know, you have to have enough design to demonstrate the safety function and the safety analysis for NRC to approve it. But there's another level of refinement in that it has to be constructible. And when we say that, we talk about the detailed design. And so you can demonstrate a design is safe and demonstrate there's an analysis that shows that you have margins to all the key parameters, but you may not be able to build it the way it's described. And so that detailed design of being able to do the review to show that it's constructible is essential to minimize changes once you get to the field.
Jim, one more thought too, as Chris was talking. I think another aspect of this question relates to standardization. You know, as Chris is talking about, you know, the ability to actually build it, I think, you know, inherent in Part 52 is this concept of standardization. And so I think there's got to be some detail so you can say this is a standardized design, that people can utilize this design and will be, you know, pretty close to the same. You know, there'll always be some differences for site-specific issues, but there's got to be enough detail. But it's really hard to kind of put into words exactly what that right level of detail is. I think, you know, everyone's going to have a little bit different view.
Ray, anything to add from the Westinghouse perspective?
No, I mean, I think Chris and Stephen kind of covered it. I would have said that an essentially completed design is, you know, a design that has sufficient information to allow the NRC to make the safety findings they need for whatever the licensing action is that you're asking for, whether it's a design certification or a COL. I mean, you know, when you look at the experience constructing the AP1000, certainly, you know, as the design was not complete when the design certs or COLs were issued. They were sufficiently complete to get to those licensing points, but you know, as construction goes on, there's always more detail that you need to add, and that goes to the fundamental trade-offs between Part 50 and 52 that we've already discussed.
Yeah, I'd like to expand on that point. I think the thing that's maybe not always obvious is, to your point, the NRC needs an essential level of design detail to be able to reach their findings, but that's different from the design detail you need to build the plant. You know, an example I like to use is if you have a 75-page discussion of the plant service water system in the design control document, along with a couple of one-line PNIDs and maybe some supporting reports. That can get the NRC to the place where it can make its finding, but you can't hand a construction superintendent those 75 pages on a clipboard and tell them to go build the plant, right? You have all kinds of other things like, you know, cable and conduit routing, piping isometrics, lots of other details. So the essentially complete design is to the level needed so that NRC can reach a finding. And then again, there's a fairly significant additional design effort that's needed to put that into the detail needed in the field. And then it's the collective job of the constructor / owner operator and the NRC field inspectors and their oversight in making sure that those details roll up under the certification level of detail that was in the licensing review. So it all has to fit together, but there's a lot more to the story beyond the DCD, for instance, and a Part 52 certification. So, I think we had a relatively small number of questions today. I'm not quite caught up on the complete list, but do you all see anything else that we need to cover before we move on to wrap up for today?
So there were a couple of questions about Duke and nuclear to achieve net zero, and would we build first of a kind? And I'll be happy to give you my personal opinion and not a Duke Energy opinion. But before I do that, I think earlier in the discussion, we talked about Andrea Vail being the acting director of NRR. Chairman Hansen announced her promotion to the permanent position. And so congratulations to her for that. We're expecting big things from NRR in the future as the climate change takes center stage. It puts NRR on point. In terms of do I think we can achieve net zero without nuclear, the answer is no. And then the next question is, will Duke buy a first of a kind advanced reactor? So that's an interesting question. It's a question of both risk appetite and cost. And so when you look at the ARDB projects, they're both looking at Washington State as a potential location for siting. Washington State has a carbon credit. North Carolina has a carbon-free goal, but there's no dollars associated with that goal. South Carolina does not have a specific goal. And so cost is a big issue. And then the concept of buy a first of a kind, it's more like develop and deploy. And so really it would depend on the group that was put together, and the risk sharing between those groups. And so the answer is not yes or no. The answer really is there value to the customer? So I could see us doing it. If there was a policy change in one of our service territories that made an advanced nuclear plant economical instantly from a carbon credit perspective, yeah, I would see Duke moving forward. I think the ARDP is a model that shows that, where you have some government support and some carbon credit state support to share that risk, to get that first design to the finish line as a demonstration, and then all the other potential owner operators can leverage off that. I think that's a great model. So the answer is not really yes or no. It's what does the business case say, and right now we don't have a positive one in any of our service territories, and that's why advanced reactors is in my group, because for us there's policy barriers between here and the future.
Thanks very much. I think that gets us to the end of our questions. I'll just ask the panelists one more time. Is there anything else you'd like to share before we wrap up? Any other thoughts? Okay, well, I very much appreciate everyone taking the time, both as participants today and to our panelists for the insights and the background that they provided. I think it was all pretty valuable. I think when you put the content of the first 3 webinars together, along with the slides, if you'd like to go back and review those, I think it generally wraps the whole story together reasonably well in a relatively succinct way, understanding that it's a bit of a convoluted patchwork of information, but puts it in a relatively organized way. We hope this series has been helpful to you all up until this point. And just a reminder, as we work to formulate and scope out and make sure that webinar number 4 is of value to as many stakeholders as possible, I would encourage you to email us your suggestions to that spot that I pointed to a couple of slides ago. And with that, we're adjourned. Thanks again very much for everybody's participation.
Thanks, Jim.
Thank you.